Glad tidings to everyone listening, and the peace and blessings of the Almighty be with you. Colleagues, I'm discussing insolvency law. I'm Katoma Gulalative. We shall begin with a definition. Insolvency is when one cannot pay their debts, and fundamentally we look at the unavailability of cash at the relevant time, and also where your liabilities exceed your assets, and so you can't settle your debts. So colleagues, you find that the rationale for insolvency is to pay off debts and also rescue the business. And in this, we find that there are three stakeholders. The first is the debtor, the person who is having the debts. We have the individual, whom we shall call the debtor of an individual, and also we have the companies or the corporate debtors. And these two personnels are distinguishable because the law handles them specifically and separately. After that, we shall look at the society as a whole. Remember, even if we are trying to rescue a business, we are seeing circumstances where someone's assets can't secure their debts. So it means we are compromising somewhere. Yet society wants to see people sticking to their obligations or debts. If at all I give you 10,000, you have to be able to pay back my 10,000 with interest, because this is what we are living in the capitalist economy of Uganda. Yet me, I'm not an advocate of interest. So, noting that, we know very well that there is criticism about insolvency law, because major people who believe in capitalism feel like if we are making people go away with their losses and we are helping them out, it means they are competing unfairly. So, bearing in mind that these criticisms are there, we also have to note that when businesses fall out, when individuals go bankrupt, when companies go into liquidation, this affects the economy. It can also lead to a shutdown in the economy. We find people losing jobs, we find income falling out, people don't have consumer, don't have purchase power because they have no money. So we find that it is also for the good of the economy to make these people here continue staying in business. So here in insolvency, we find that it is commenced after the service of a statutory demand. A statutory demand, this is a demand which is given to the debtor by either the creditor who wants to recover their debts or their monies. So, in this, we find that Section 3 of the Insolvency Act of 2011 states that once you are served with statutory demand, you have to give reasons as to why we should not proceed with the insolvency proceedings against you. So, in that instance, we find that there is leverage where you can apply for an interim protective order. And here I'm going to be specifying where an individual applies for an interim protective order against a statutory demand which is commencing insolvency proceedings against them. They are, in this instance, going to provide other avenues or even rebut the presumption, because the presumption is that if you are served a statutory demand, it means you can't pay your debts. If at all you have the ability, then you can provide evidence, avail evidence to court, providing the presumption that yes, I can pay my debts, and there is no reason as to why I have to go into insolvency. So, also you find that once you are granted this protective order, we have very many avenues, and these are the mechanisms that a person or a corporate body can go into to also protect itself from going into insolvency. Insolvency is costly because it provides professionals and technocrats who are supposed to be paid for their work when they are securing your liabilities and also making sure creditors are satisfied. So, In this, we are going to discuss the informal mechanisms which most people can also take advantage of in order to prevent insolvency. So in this, I'll start by talking about the assistance of consumer debtors. In this, I mean persons who are having small businesses or individuals, and you can get help from friends, you can get help from family, and in this instance, you are even asked for more financing, because we find that there are very many avenues for individuals to seek help. You don't need to necessarily to go into insolvency, because insolvency may lead to very many costs. So in this, we have also to refurnish the ability of individuals to seek debt or loan advice or counseling, because the professionals who are experts in this, you find that if you are going through some hurdles, it is because of something that if you put on table with your creditors, they can understand and sympathize. For example, you can claim that you want some protection because the difficulties are emanating from redundancy. For example, COVID-19, businesses were shut down. So I can also say, because of redundancy, that's why I'm suffering and I'm not paying my debts. Or ill health. People may fall sick, and the sole proprietors of their businesses, can we say that they're afraid to pay their debts? We can give them time to recover and also to pay their debts in the future. So this is a mechanism which is informal, but if you put it on the table and you give these reasons, you can be given a leverage. Then also, we have also what we call bank rescue. Bank rescue comes up. There are very many arrangements when you go to get a bank loan, because most people don't read the terms and conditions, people don't read those nitty-gritties, they fail to see these avenues. Once you get a bank loan and you feel you can't pay it because of a sufficient reason, which if you discuss it with your bank, they can understand. You can go to that avenue, you meet them, you tell them the reasons as to why you have failed to meet the obligation at a specific period, which has been agreed in the agreement, and they can give you this avenue of rescuing your business without going into insolvency. Then we have contractual arrangements. Remember, when you're making contracts like loan agreements, or when you're giving out money with money lenders, these agreements you have also to put in your terms, which are going to help you. Remember, this is business. Business has losses and profits. So when you start making your loans, make also provision for arrangements when maybe you fail to pay in time. In this instance, you can agree on how you're going to be paying this money without accumulating compound interest. So members also have to agree that before you get a loan, you have to also get some advice, technical advice, which will give you it enables you to know your rights as a person who is getting a debt. Of course, I know when you go into practice, you want a debt, you want a loan, you want money. You have no time, and this person has a higher bargaining power. In most cases, they will manipulate you, but still, you have to be conscious. Then we have deed arrangements. With deed arrangements, I'm not going to delve into deed arrangements during this informal aspect of the of mechanisms, because the law has come up and put deeds with the formal part, where we're going to also deal with the deeds, how you create a deed in your loan agreement or when you're getting a debt, and this deed can be enforceable or binding between you and your creditors, so that they can't go into rigorous insolvency proceedings, or they can't use rigorous methods of securing their debts, e.g. foreclosing, e.g. maybe selling off your assets. So that is one of the instances where you are going to benefit from the informal part. It's about negotiation, it's about agreement, it's about going to ADR, advanced dispute resolution mechanisms. You sit, you agree, and when you agree, you make binding contracts where you can also refer to them and say, no, you agreed on this, you can't foreclose me, and you continue with your business. It secures you and gives you a better runoff and rampage in these circumstances, because crisis is inevitable. So let's now go back to the Insolvency Act. Members, with the Insolvency Act, I find that here people think it is a do or die. That if you go into Insolvency Act, the Insolvency Act, there is no way you're going to be rescued or your business is going to proceed. But that's not the truth, because in our new Insolvency Act, we have put up very many corporate rescue mechanisms, which also are formal, and once you drive into them, you're going to be helped. So let's get to the point where someone has served you as a trade demand, and this person here is really trying to enforce insolvency proceedings against you. Here, you can proceed and have an interim protective order for an individual. This interim protective order is provided for under Section 5 of the Insolvency Act, which is going to help you to stop these proceedings from commencing. And when you get this order, for the companies, we shall call it the memorandum. Once you get this memorandum or this protective order, you can now look at this avenue of individual voluntary arrangement or corporate voluntary arrangement. That is a very good mechanism for you to stop insolvency proceedings and also agree with your creditors. You sit on table and discuss. So let's first look at individual voluntary arrangement. Under the Section 1 or the division section of the Insolvency Act, it defines voluntary arrangement. Yes, this is a composition where you sit with your creditors and agree on how you're going to deal with your liabilities. Then, under Section 195 or 125 of the Insolvency Act, it provides for the order once you have agreed. Because this is about a meeting, you convene a meeting, and in this meeting, you agree. And after agreeing, you sign. After signing, it means, yes, you are starting to secure your debts through a mechanism that is not rigorous, like selling off the business or ending the business. So in this, we are going to gazette this order under the regulations. That's Regulation 71 of the Insolvency Regulations of 2013, and you are going to appoint a supervisor who is going to watch out during this voluntary arrangement. Then we are also going to look at the secured and unsecured debt creditors, because the secured creditors, these are creditors for them we know under Section 97 of the Insolvency Act. Maybe they are through formal agreements or arrangements, so it means for them they are known by law. Then there's unsecured creditors who are under Section 12 of the Insolvency Act. For them, they are known by law, but they have debts against you, and still you have to pay them. So in this instance, once you agree, and you get an arrangement order, these people here are obliged to have a view or to have a voice in voting whether or not they can proceed with a voluntary arrangement. But because it's about negotiation, and they know very well you are a customer, they want you to be also a future customer, they don't want to see your business failing. Most people agree on this. So long as you come up with a plan that is going to execute and set off your debts. And it is a binding contract, by the way. The moment the arrangement order is granted and it is supervised by court, and the secured creditors have agreed anonymously, even if the unsecured creditors are not agreeing, because in most cases their debts come after you have secured the ones for those of the secured creditors. They have no say in this. They will have to be having a binding arrangement. They can't rebut any outcome of the arrangements. So after that, let's go to corporate arrangement. This is in most cases with corporate bodies, where we have a voluntary arrangement for corporate bodies. It is also a good arrangement because it is provided under the Companies Act. It is not under the Insolvency Act. It is under the Companies Act, under Section 234 of the Companies Act, and it is supposed to be notified to the Registry of Companies and also attached to your memorandum of articles of association because in this instance we are seeing you are going to have a different managerial role. You are getting a different person who is going to be managing this business. So in this instance, it is a very good corporate strategy, because we look at your ability to generate profits in the long run to pay off your debts. You're looking at your effective credit control procedures, because if you have an effective credit control procedure in your company, we know very well that even arrangement can apply, because appointing these administrators are very easy. Then you have your corporate strategy for finance survival. If at all you know very well that your assets, if they are utilized very well, you can pay off your debts. We can go ahead and incorporate this corporate voluntary arrangement under section 234 of the Companies Act. So let's now proceed to the other formal part of the insolvency procedure. After you have seen that your business is now put in jeopardy, we are not seeing a way of paying off our debts. There is another which is called administration. I like this one because it is also one of the areas where you can delve into to protect your business or company. For this, before even you go to administration, there is a provisional administrator. This provisional administrator is also like an interim remedy, where you go and invoke section 139 of the Insolvency Act, and on that you protect your business from going into insolvency proceedings, whilst you appoint an administrator to rescue this business. In most cases, when you get into administration or provisional administration, you are investigating the business, looking at the properties, the affairs of the business, and seeing how you can have a financial circumstance to secure this business from failure. Then also we have a problem of accounts. The moment you go into provisional administration, you are going to have a different or separate book of account, where you are going to get monies that are separate from the business, from the company's monies, to secure off the debts. So you begin now financing the debts in the long run, so that your business continues, whereas also the debts are being secured or are being paid. So after that, we also look at the termination. In the case of Uganda Telecom Limited versus Ondoma Samuel, this was they represented by Alaka and Company Advocates. This is application number 12 of 2018. Justice Mobile talked about administration and provisional administration, and they stated that this is a corporate rescue mechanism. So it is not meant to put or to dispose of the business, but however, it's supposed to treat the business as a going concern. A going concern, I mean, it is going to continue. It's going to continue doing business, or it's going to continue performing its duties, whereas also paying the debts. So don't think because you've appointed an administrator, now your business is out and can no longer continue doing any other thing. So that is for the aspect of administration. Also, if you go into the administration without the provision one, which is an interim, that is provided under section 162. And with section 162, once you go into the administration part, we make an administration deed, which is provided under section 149 of the Insolvency Act. Here, this is a binding arrangement, the administration part. Once you go into administration, it is binding on the administrators and is on the all creditors, be it secured or unsecured. However, these people have a vote. If they vote not to go into administration, it means you're not going to go there. They will look at other rigorous means of getting back their money. Of course, they can foreclose, they can sell off your assets. But however, once the secured creditors, those who are known by law, agree on administration, even if the unsecured ones are contending or they're vetoing this administration order, they have no say. They have to just comply. So it is a binding arrangement, and you're not going to have, or you're not going to face insolvency proceedings against you. By insolvency proceedings, I mean you are going into liquidation if you're a company. Liquidation means you're ending the business, because these are one of the forms of putting an end to a corporate body. Or if you are an individual, you're going into bankruptcy proceedings. If you go to section 20, you will understand what I mean by bankruptcy proceedings. They're going to declare you bankrupt. So that is it. Let's now go to another mechanism, that is receivership. Receivership, it is just technical. This is where some these individuals are going to they're going to appoint a receiver who is going to manage all the estate or the business and get back their areas or their loan or their debts. This is by the creditors. However, with the receivership, it's not supposed to also dispose of the business. However, when it comes to some point in time, they may also dispose of business, like if you go into receivership under the Mortgage Act. Because also, if you read section 22 of the Mortgage Act, provides for receivership, where they apply for a receiver, and this receiver here will just foreclose the mortgage property. Those ones, for them, they are unruly. If they come, they want to get their loans, they want to get their money. So, also, receivership is another way of getting back your loan, your debts from your debtors who have failed to pay because of insolvency. Then we have what we call government bailouts. These are they just apply to government to bail you out if you're a business. These are the informal in some aspects, also, but they are also formal in some aspects, because Ministry of Finance gives all issues handouts. You mention in business they're going to bail out. But for me, as an individual, I don't advertise or I don't advocate for bailouts, because it is an incentive which makes businesses to go into risk-averse arrangements or debts, or make risk-averse decisions, because they know once they fall into losses, they will be bailed out. And also, it is also breeding an unfair ground in capitalism, because in capitalism is the survival of the fittest. Once we go into business, the more you work, we are incentivizing that those people there who are working hard, they receive more gains. So if you get more profits, you enjoy the profits. Why is it that when you get losses, you want us to share your losses by going to the taxpayers' money to bail you out? I feel it is discriminatory, because individuals or small businesses can't get those bailouts. It's only those big businesses who are making massive profits. So it is unfair to me. I hate those bailouts. I find it is undemocratic. It is socialistic in nature, and it is also arbitrary in nature. It is because of these bailouts that we are having those very rich people who can't even account for their riches. So that is it. With that, I want to also now discuss the aspect of loans and creditors. I talked about it earlier, that whenever you're going to get a loan, you have to get advice. Don't just fall into a loan like you can manage it as an individual. No, it's not possible. You have to get advice. You get informed information, or you get informed consent before you even sign documents on your loan. Why should you make a decision that is going to affect the future of your business without even getting advice? There are very many people who are experts in giving such counseling and guidance. You can contact them. There are insolvency practitioners and loan management practitioners, lawyers who have learned and agreed and appreciated the field of credit. You can consult them. They can tell you about the nitty-gritties. They can read for you these terms and conditions in the agreements before you sign them, before they become binding onto you, so that when you conclude your arrangement, or when you conclude your loan agreement, or your debentures, you are secured. You know what you're falling into. Get lawyers. Get people who are going to secure you a good deal, and also to see the future of your business prospering, not going into losses. So with that, thank you very much. I remain Katoma Latif. In my bio, you can get my contacts. I can give advice on any loan facility, and also I can give advice on securing an appropriate way of paying off your debts, which are becoming very problematic. Thank you very much.